So welcome everyone to our 2025 Vis Moot and Vis Moot case discussion, organized by the Chartered Institute of Arbitrators Brazil branch. So this is our third event in a row, and I hope we can make it to become a tradition for the Mooties and arbitrators that take part in this wonderful event. So my name is Cristina Wagner Mastrobuono. I am an independent arbitrator based in São Paulo, Brazil. I'm a fellow from the Charter Institute, and I am currently the chair of the Brazil branch. I will be moderating today's webinar, in which we will be discussing issues 1 and 2 from the Vis Moot case of this year. So we have the honor to have the presence of 3 brilliant lawyers and arbitrators from Helsinki and a brilliant lawyer and arbitrator from São Paulo, Brazil. I will, before I start with our webinar, I will give briefly the word for them so they can briefly introduce themselves. So let's start with Ana Maria, please.
Well, hello, nice to meet you all. I'm very happy to be here. Always a fan of the Moot, as I was a Mootie 20 years ago with the University of Vienna back in the days, and ever since have looked forward to contributing to these events. I'm a partner at Hannes Snellman, will be the managing partner starting 1st of April. I'm a dispute resolution lawyer with 20 years experience in the branch, and I think I do what I do because of the Vis Moot, so I'm happy to give back on the occasion. My practice is a mix of both counsel work and arbitrator work, predominantly counsel work at the moment. Do both commercial and investment treaty cases, international, regional, and national proceedings, and then have acted as arbitrator in over 30 arbitrations thus far. Very happy to be here.
Thank you, Ana Maria. Let's follow the alphabetical order. So Bernard, you are next.
Thank you, Cristina, for the invitation to speak here today. It's a pleasure being with such experienced colleagues. My name is Bernard Potsch. I am a lawyer seated in Rio de Janeiro, Brazil, a fellow from the Chartered Institute of Arbitrators, and together with Cristina, also a member of the board of the Brazil branch as a vice director of education. I'm a partner at Batista Martins Advogados, have been practicing arbitration for the past 15 years, actually 17 years now, and been to the Moot, following the Moot for the past 15 years. So it's a pleasure discussing this with all of you today.
Thank you, Bernard. So next is Heidi.
Good morning, everyone in Brazil, and greetings from Helsinki. My name is Heidi Merikalla-Teir. I'm chairing the FAI board here in Helsinki. When I'm not doing the work for the FAI, I'm an independent arbitrator and mediator specializing in commercial disputes. During my career, I worked for large law firms here in Helsinki, but then I did a kind of a sidestep to FAI during years 2015 to 2019, when I was the Secretary General for the FAI and a director at the Finland Chamber of Commerce. After having worked at the FAI for 5 years, I returned to private practice, worked for a law firm as a managing partner for that law firm, and now since June last year, I have my own practice and do what I love to do, serving as an arbitrator and mediator for commercial disputes. So thank you very much for your kind invitation. It's a pleasure to be here.
Okay, thank you, Heidi. And now Henrik Sajakorpi.
Thank you, Cristina, and greetings to everyone. My name is Henrik Sajakorpi, and I'm the Secretary General here at the Finland Arbitration Institute, where I lead the FAI Secretariat and also drive our domestic as well as international activities in cooperation with Heidi and the FAI board in general. And previously, before joining the FAI last year, I used to work with dispute resolution as a practitioner myself in a Finnish and Swedish law firm called Procedural. but I'm now very happy to be at the Institute, and it's been a wild ride so far, especially with the Vis Moot and everything. And speaking of the Vis Moot, I have to bring up also the fact that I did the Vis Moot myself approximately 10 years ago, or is it now actually 11 years ago? And I've also coached the University of Helsinki for at least 4 years or 4 times. But that's my background. So very happy to be here, and I'm looking forward to the discussion.
Okay, thank you very much, Henrik. So, as you see, we have here the Secretary General and the Chair of the Board of the FI. So, as much as we would like to enter in the details and give the official opinion of the FI, of course, that's not possible. And also, I think that would take away all the fun of the Vis Moot. So this is a disclaimer that we will not be discussing, we will not be giving you the right answer about the case. And therefore, I will start reading a disclaimer that applies to everyone that is now taking part. The views and opinions expressed by the speaker during this webinar are their own and do not reflect the official position or policies of FI. The information shared during this conference is for educational and informational purposes only and should not be considered legal, financial, or professional advice. Vis Moot participants are encouraged to seek independent guidance specific to their own circumstances. Additionally, this event may be recorded and or photographed for promotional and archival purposes. By participating, you consent to being included in any media captured during the conference. Finally, we will not be giving you any advice about the specific case of the Vis Moot. Our discussion will be in abstract and again, does not reflect the FI understanding about the issues of the case. So again, and this may be a little bit frustrating, but we will be doing our best. And before we start with the questions, I will give you a short introduction of the case so we can better understand the discussions. Also, please feel free to send your questions in the Q&A section. We will try to answer all of them. So this case, as always, the case involves a very interesting and up-to-date discussion. Two companies engaged into a purchase and sales agreement. Claimant, Green Hydro PLC, an engineering company based in Mediterranean, specialized in the design, construction, and sale of plants for green hydrogen production. And the respondent, Equatoriana Rain Power Limited, which is a fully government-owned energy company in Equatoriana, operating in the field of renewables. The PSA was signed after a bidding process and a negotiation phase. There is information about the scope of the contract and the requirement of a 25% minimum local content of the products, which we will not be exploring now. This is a matter of the second webinar. In October 2023, local elections in Equatoriana led to the replacement of the Minister for Energy and Environment. The new minister announced a critical revision of the government's green energy strategy and the review of all energy-related contracts to determine if they were still in the line with the new government's energy policy. On the 29th February 2024, respondent gave notice of termination of the PSA, citing a 28-day delay in the submission of the final detailed plans, which were due on February 1st. Also, the termination was attributed to the new view that the contract was no longer in the line with the government's objectives. There were attempts to negotiate, and respondent demanded a further price reduction, what claimant could not accept. At the same time, the offices of Mr. Dayman, claimant's main negotiator for the PSA, were raided by the Equatorian Public Prosecution Office. Mr. Dayman was then imprisoned and his passport was seized. The prosecution office actions were based on allegations raised by respondents' new CEO, Mr. Lacour, who maintains close contacts to the prosecution office. During the raid, computers and laptops were seized. Following the failure to negotiate a dispute, claimant initiated arbitration on July 2024. However, the respondent challenged the tribunal's jurisdiction, asserting that mediation was a mandatory precondition, rendering the arbitration agreement inoperable. In its answer to the request for arbitration, the respondent sought to exclude a communication that was brought as evidence by claimant, but was marked as without prejudice offer, Exhibit C3. Also, it introduced as Exhibit R7, a communication between the claimant and its counsel that claimant argues to be under attorney-client privilege and confidentiality. Respondent also disputed the application of the CG to the PSA, asserting that its applicability had been excluded, and this issue will also be explored on the second webinar. We'll be focusing today on the procedural part of the case, meaning issues 1 and 2. Issue 1 relates to the consequences of not officially starting a mediation process and to what extent all the stages of a multi-steps clause must be executed. Second, there is the discussion about exclusion of documents from the file that allegedly had been submitted in breach of legal privilege or confidentiality agreements. So what we have the discussion about arbitral tribunal discretion under FI rules over the admissibility of the case and its jurisdiction, and the use of documents as evidence that could be under privilege or confidentiality. So I guess this making it short was able for you to understand. And the dynamics will be that I will be addressing questions to the participants, and Bernard Potsch will more to the end give a deeper understanding about the use of the documents in the case. So I will start with Henrik. Henrik, so this Vis Moot has a feature, all the Vis Moots, they have the feature of alternating the arbitral institution whose rules are used in the case. So I think this is wonderful. It's like when we have World Cup or Olympic Games that we have the opportunity to go and study and know a little bit more about a certain country. So in this case, it provides the opportunity to learn more about the use of arbitration in Finland, to have a better understanding about the arbitration culture in your country. So I want to start asking you about the FI. Could you give us an overview about important aspects and numbers about the institution?
Certainly, thank you. That's a great question, and let's see how into details I can go in this short seminar. But sure, the FAI is an old arbitration institute in many ways. I mean, we were established already in 1911, which makes us over 100 years old. And at the same time, it also makes us one of the world's oldest still operational arbitration institutes in the world. We were originally established to handle disputes pertaining to product quality issues in foreign trade. But since then, those early days, of course, the range of disputes that we handle here has broadened significantly. Our rules, or like first arbitration rules, they were drafted in 1910, and they've been obviously continuously updated thereafter. And the last revision of our rules took effect in last January 2024. As you already noticed from our name, the we are part of the Finland Chamber of Commerce, but at the same time, we're also independent from it in terms of decision making and otherwise. We have our own office space, our own IT systems, and our own staff, and so forth. Then perhaps it would be good to mention how we are structured in general, since we have now a member of the FCI board here, and then I represent the secretariat. So that already signals to everyone that there seems to be at least secretariat and also the board at the FCI. So that's how we are basically structured when it comes to really the administration of disputes. So we have the FCI board making decisions, and then we have the FCI secretariat basically handling all the daily administrative work involved in administration of arbitrations and mediations. And we also obviously prepare decisions for the FCI board. And then we also have like support functions that assist us in marketing and so forth. But let's not go into those details here now. In terms of figures, perhaps that gives everyone a bit of a grasp as to what kind of an institute we are and what kind of a caseload we tend to have here. I have the statistics from 2023 before me here on my computer. The statistics for last year have not yet been published. They will be made available in February. So I will not give you like older data, but I hope it suffices nonetheless. So in terms of like volume of cases, we had 71 cases here at the Institute, arbitration cases. And out of those cases, approximately 35% were international, which means that in those specific arbitrations, at least one of the parties was non-Finnish or not based in Finland. We have a track record of efficient handling and resolution of disputes. The median duration of arbitrations handled here under our regular rules was 8.9 months. So that's quite fast also internationally speaking. Heidi, do you have something to add as to what we are or what it is that we do here at the FCI?
I think you explained it well. As to the caseload, I might mention that it of course varies from year to year. I think the highest figure has been over 100 cases, but as we all know, sometimes we have ups and downs also in disputes, and we maybe different times and market situations affect. But roughly between 70 and 100 would be the normal caseload that we have. And what we are very happy of is the figure that you just told about the international caseload, which has increased all the time. And we are happy to see those kind of big players, clients to arbitration that we would expect to see in some other institutions. So they also use our institution. So we are very, very happy for that. And we try to be an institution that is known for its pragmatism and efficiency, as Henrik noted. And maybe it's good to understand about the Finnish law that in terms of Finnish Arbitration Act as well. So basically, when we had the time limit for rendering an arbitral award under Finnish law, so that's really a time limit. And should you exceed that time limit, so the tribunal would not have jurisdiction most likely. So sometimes you hear from international practitioners that why are we so strict with the time limits here in Finland? But that's one of the reasons. So it's really, there really is a time limit, not only in the rules, but also in terms of the tribunal's jurisdiction. So, but that's maybe just a couple of comments to add.
Mm-hmm. Oh, this is very interesting, because one of the aspects that struck me by reading the numbers, which of course I entered in the site and read a little bit about the FI, was this feature, the short, the average number of months that is pretty short. I mean, considering that you that these are international arbitrators, and I guess also very complex ones. So this is the explanation that's in the law. So very, very interesting. And Heidi, another interesting aspect that I saw searching about FI, and this is related to the FI board, which you chair, is the great diversity of the backgrounds of its members. So I guess it's related because it's from the Chamber of Commerce, but so I want to hear your opinion, because 2 points stood out to me. So first, the participation of a judge of the Court of Appeals from the Helsinki court, Tero Kujala, I think this is the name. And second, the significant number of representatives from the industry. So could you comment a little bit about this?
Yes, thank you for the good question. So maybe I start from what already Henrik a little bit referred to. So the rules, the FAI rules were modernized or have been modernized many times during the past years, but the, so to say, big revision of the rules was in 2013. So that's kind of a one year when we tried to change everything to become more international. The rules were streamlined to correspond to ICC rules at that point of time. And also during that period, we also changed the rules regarding the FAI board. And nowadays, if you look at the rules, so it actually says that we need to have both international members of the board and then Finnish nationals as well. And as Henrik said, the case laws has become increasingly international, and therefore, of course, it's very valuable to have international members at the board as well. And we normally, when we have the board meetings, so we start with the international cases, and then all the board members will attend the meetings and will make decisions on those matters. And then should we only have then, or if we also have Finnish cases, we continue with the Finnish board members and we'll make decision on those. But then as to the diversity of the board members, so we think so that it's good to have different kinds of views at the board as well. Not only lawyers, which is of course valuable, and biggest part of the members are lawyers from background and attorneys from law firms. But we also have considered it very valuable to have a general counsel for bigger companies joining the board. And as you mentioned, we also have one judge at the board as we speak, and we have actually have during the past year, since I think 2013, we have always had someone from the judiciary. And the idea being that sometimes there are cases where it is actually good to have an arbitrator with a background from court system. Although majority of the arbitrators are attorneys from law firms, so sometimes we have also cases where we want to appoint judges from courts, not only from district court or appeal court, but also from the Supreme Court. Based on their internal policies, Supreme Court judges may have one arbitrator appointment at the time. And therefore, sometimes you also see judges sitting in commercial disputes. And that's why we have also appointed always one member from court system. So we have considered that it's a good thing. And we actually just today had a board meeting of our new board who started 1st of January. And it was, again, I think, good to see how the discussion is, I think, much better when you have different views from from people from different backgrounds. So that's the reason why you can see a judge sitting at our board.
So I think this is also very important because you bring the users, yes, because who are the arbitration users? The industry, yes, not the lawyers. We are just instruments, yes, and they can, yes, they can be there and really give, I mean, being part of a decision-making process. So
Yeah, they can give the user's perspective, and sometimes we lawyers from law firms, we have lived some in our own bubble in a way.
Yeah.
So it's also good to understand that behind the counsel there is always the client and the company who is using actually the arbitration, and that's why we consider it very important to know what actually the users themselves think, and it has always been valuable to have general counsel attending the meetings.
Okay. So now I want to make a clarification here, because there was a question about which case we are talking. So we are talking about the Vis Moot case from this year, 2025. So, and turning a little bit more into the case, the subject of the case, I want to ask Ana Maria, which is a very much experienced, not only lawyer, but arbitrator also. And so how has arbitration and mediation been used in Finland? Is it a preferred method for resolving dispute in commercial matters? And also, what can you tell us about the issue of the case in your practice?
Well, I think, I mean, arbitration has a very long track record for commercial disputes as the dispute resolution mechanism for commercial disputes in Finland. I would say that the majority of commercial disputes are handled in arbitration. I think the exceptions are the ones that go to court, especially in the national spectrum, would be the ones that involve governmental entities or municipalities, for example, which then force the counterparties to actually litigate before the courts. And Heidi and Henrik, feel free to agree or disagree. But it is very much my experience and our experience at the firm that most commercial cases are subject to arbitration clauses in Finland, have been and remain so, because it is the fastest form of dispute resolution with the least problems, especially when you require a fast resolution of disputes. With mediation, I think we've seen a development over the past years, and especially here, Heidi, feel free to pitch in as you now sit also as a mediator. I think I came back to the Nordics 13 years ago and had a mediation here and another one there. And regardless of how much we pushed for mediation to be used as the dispute resolution mechanism, where we saw that there was opportunity, for example, for continued cooperation between the parties, it didn't really stick in many instances. But we've seen a shift in the past 5 years that all of a sudden there's a lot more appetite for mediation. And I think this is thanks to a number of factors. The more the market has good experiences with mediation, the more the word travels. There's also more trained mediators on the market and people who have sort of specialized predominantly in mediation. There's been a strong push by the government to have our judiciary trained in mediation as well, which then of course has meant that members of the bar have been trained in mediation. And then this is a sort of rolling stone effect that once you open the lid in one place, it results in sort of further appetite for mediation. I don't see a situation where mediation would overtake arbitration, because the issue still remains that in some cases you need the ultimate decision, and it's not always a settlement agreement. Although we have developments in the international sphere where you can also have international recognition of a settlement agreement as a result of a mediation. So there, I think, there's good development for mediation, but we're certainly still a country where predominantly commercial disputes will be resolved ultimately in commercial arbitration. In terms of multi-tier clauses, I think we do see them, but we also see that going to mediation is not dependent on whether you actually have a multi-tier clause or not. And in that sphere, and actually going to the question of the moot problem, do we advise in most cases that you should have an elaborate multi-tier dispute resolution clause, then not necessarily, because in many instances, you will have access to mediation regardless of the dispute resolution clause that you have. But if you have an elaborate clause, you may end up in a lengthy discussion about whether you fulfill the criteria, whether, you know, it is a question of admissibility or jurisdiction, and where that will take you. And I think what we've seen in practice is that when there's will to mediate, it is not a question of whether it is actually in the clause or not. I think in my 13 years of practice in Finland, I can name one instance where the clause itself was helpful because the other side initiated an arbitration and we were able to force them back to the table and conduct a mediation and then actually settle the case in mediation. All other mediations that I have been involved in have actually been instances where the dispute resolution clause just had an arbitration clause, but we managed to agree on a mediation because there was a will and a way to do that. I think, I mean, where I see the benefit of having an institutional mediation clause is exactly now that institutions have more familiarity with mediation, and especially that they can recommend good mediators, because I think that's the value add, especially if you come from a market outside the sort of geographic framework of a specific institution. So, for example, if you had an FAI clause, I think where the FAI would come in handy would be sort of the ability to recommend mediators who are sort of familiar with Finnish law, or, for example, experts for the purposes of mediations. And I think that's another thing that I like to mention in the context of mediation is that we've had very good experiences with using some tools that we see in most arbitrations, like having expert reports before we actually go and mediate, especially if it's technically complicated questions, then you actually know what you're talking about if you've conducted your background work. But then, of course, I mean, for clients, they mean very different things. If it's an arbitration, they provide us with information. Some people will have to testify as witnesses, but the dispute is, so to say, in external counsel's hands, whereas a mediation very much requires a lot of time from the representatives of the company itself. And I think all mediations I have attended, the ultimate solution is actually very much a product of the commercial thinking of the client rather than the legal issues involved by counsel. So from that perspective, I think with the 20 years in practice, I find mediations a fantastic opportunity to always learn about the client's business, whereas an arbitration is always, we play the key role in binding the law together with the facts. But then, I mean, going back to the issues in the case, whether if in Finland, there would be a strict line, whether you would foresee a multi-tier clause as a jurisdictional issue or a question of admissibility. I think there's legal literature sort of discussing both ends. And I think one article that you will find in English will be a person who is well known to the Finns on the webinar as my former boss, Mika Savola, who has also been one of the people holding the pen for the rules revision in 2013 and who had Heidi's role back in the days, has written an article on multi-tier dispute resolution clauses under Finnish law back in the days. And I think there's one reference that you could go to. But I would say that in legal literature, we recognize both the possibility of the mediation requirement forming a bar to jurisdiction as well as admissibility of the claim. And where parties are in principle free to draft a multi-tier dispute resolution clause, which set mediation as a prerequisite for the tribunal's jurisdiction, the effects of the clause depend very much on the party's intention, and where no intention can reliably be determined, then of course the wording of the clause, and that would be subject to what the arbitrators then interpret. To form a bar to jurisdiction, the mediation requirement would have to be phrased in a very, very precise way. And there, an MDR clause where the parties expressly waive their right to arbitration until a mediation is terminated would likely form a condition precedent for arbitration. So I think you would have to have very specific language. And I think this goes back to then the question of if arbitration is the ultimate form of dispute resolution, then you should also have a right to go there eventually. But then this is going to be a contract interpretation question, and then of course a fantastic question for the Vis Moot, because it allows you to argue both sides of the argument. If the MDR clause is vaguely worded, another strong commentator on Finnish law, that would be Mika Hemmo, advocates, in keeping with many international sources, for a pro-arbitration stance. And you know, so this, I think you will find elements in Finnish law that go both ways. And I think Mika Savola has also raised the point that the possibility that the tribunal can consider whether the mediation would have likely led to a settlement is a question that you could take into account in the assessment of whether it is a bar to jurisdiction or not. And in any event, I think in that determination, you have multiple considerations that you would have to take into account. And then, of course, those would have to be argued by the parties to be considered by the tribunal. If the tribunal were to, if we so to say, overstep their jurisdiction by disregarding the parties' arbitration agreement, when the claimant has failed to comply with the procedures for initiating the arbitral proceedings, this could form then a ground for setting aside. I think this goes back to another point, is that Finland is a very pro-arbitration jurisdiction, and from that perspective, to argue that an award should be set aside is a lengthy process, and you would really have to have the arguments to do that. If, however, the mediation clause only leads to the claim having been premature, and the tribunal were to give an award in spite of resulting in admissibility, this would then not form the basis for setting aside an award. And proceeding to arbitration despite a binding mediation requirement may, on the other hand, then have an effect on the division of costs of the proceedings. So that's another aspect that you may want to take into account. And then theoretically thinking a breach of mediation requirement in a multi-tier dispute resolution clause could entitle the respondent, for example, to contractual remedies such as liquidated damages, which is, of course, a theoretical point that could be advanced. But I think the big takeaways from a Finnish perspective is Finland is a very pro-arbitration country, and from that perspective, you would have to have quite a clause to be prevented from bringing arbitration, but that does not say that you shouldn't take care of making sure that the steps in the multi-tier dispute resolution clause are fulfilled before you proceed to arbitration, to avoid cost elements and other issues in the process. Anything to add, Heidi or Henrik?
I think you had very, very good comments, and I don't comment the case and the questions that you just raised and commented, but maybe to add on what you already noted about mediation. So as Anna-Maria said, mediation has been kind of a hot topic in Finland for, let's say, past decade or even 20 years. And but I see positive signs of mediation becoming increasingly popular. I think that is because court mediation, as Anna-Maria said, there has been a lot of movement in the courts towards mediation. A lot of cases are mediated at the court. Of course, considering that not too many business disputes or commercial disputes go to the courts, except for those that Anna-Maria mentioned that relate, for instance, to municipalities. So basically that means that private mediation where business disputes would be mediated, that's still relatively rare. However, as having been trained as a mediator, and I see the cases, some cases that are coming to mediation, so I think one of the biggest reasons for the cases coming to mediation is that the attorneys representing the parties have apparently more and more knowledge about mediation, and they have a good discussion with their clients about different tools that you have for dispute resolution. As Anna-Maria said, you don't really need to have the mediation clause, but you can agree on mediation even though the clause would only direct you to arbitration. And as Anna-Maria said, mediation requires participation from the parties themselves and the leadership of the parties. So you really need to have and take the time and say to your client that you really need to attend the mediation, and the preparation for the mediation is a big part of it. So that is something that I see and feel that that's difficult to explain to the clients, that you really need to be there, and you are actually the one who is talking in the mediation, and it's not the mediator who will say and render a kind of an award at the end of the mediation, but it's for the parties themselves as a main rule to find a way towards the settlement. And of course the mediator facilitates the discussions and can be of big help, and should be as well, but it requires a lot from the parties themselves. But as I always say, the parties participating in the mediations where I'm mediating, I always say to them at the beginning that I think a rational business person would always try mediation if there isn't any need to have a binding arbitral award, but to use some time for at least considering mediation and discussing about it with the opposing parties. So I think it's worth a while. So, and I see positive developments. Yes.
Yeah, and I would add to that you know, sometimes even if the mediation per se would not be successful, you always manage to settle some part of the dispute. So if you have, for example, a super complicated infrastructure project or construction project claims, you may be able to mediate part of it, and then you will have, you know, diminished the number of questions that you actually have to take to arbitration. And you may want to take to arbitration only the question that is actually a question of legal interpretation, whereas you might actually mediate issues that are that are different in nature. So I think I would agree with you, Heidi, that you should always try. And I think the instances in which I've seen that it becomes very difficult is when there's actually no business potential. So there's nothing that you can build on to go forward. Or the case that you mentioned that, you know, the company has 100 similar agreements and just needs an interpretation so that, you know, for their own protection, they're moving in the right direction. I would say one caveat to what I just discussed, and that is the sort of multi-partite setup. So I think what I just said would apply in a bipartite setup between claimant and respondent. I think on the questions where you would have, you know, potential issues with consolidations of joinders, then this gets increasingly more difficult, and you should be careful that you know who the parties are, regardless of how you proceed, whether it's through mediation or not.
Okay, so thank you very much. You brought a lot of information. I was writing down my head a lot of follow-up questions, but what stuck into my head was what Heidi said. It's a rational thing going to mediation. Yes, I guess maybe the biggest problem is when disputes, they may be already in such a aggressive stage that doesn't matter. So parties are not willing, they are not rational anymore. So they will not go into a mediation or negotiation process because they already passed that situation in which they could be there accepting other points of view. So that's why maybe this new trend that is being discussed in many conferences about the windows of mediation that you open in the arbitration process. Yes, because then after the exchange of some of the briefs, you may come back a little bit to rationale and think about the issues again. So. And I just want to use some of the questions that were made here about this issue. So one of them is, doesn't mediation help before trying arbitration? I guess this was already answered by your comments. Yes. And
I would add to that point, I mean, it's not just that, you know, you may settle parts of the questions, you may also clarify what the dispute is about. And actually coming back to your point, Cristina, about, you know, sometimes parties are fed up in settlement negotiations. I don't know, Heidi, whether your experience reciprocates what my experience is. My experience very much is that they may have tried settlement agreements for 2 years, and then we bring it to mediation, and just if you have a good mediator, you're actually capable of taking an issue at a time, where settlement negotiations, there's all sorts of other things that interfere, like egos, or the fact that nobody really knows what we're talking about. The issues are not really studied well enough for somebody to have an informed decision. And I think that's
yeah, and in that sense also, one thing that I've noticed many times, and always it strikes me, that quite often, even though the parties have negotiated previously with their lawyers or without, so quite often when they come to the mediation session or the mediation day or days, depending on the case, so still it might be that it's the first time the leaders of the company, being a CEO or a leader of a certain division, that they actually meet face to face. They may have been involved in some correspondence, and some letters have been exchanged, and maybe the general counsel have been involved in negotiations. But when the leaders really meet face to face, they see that, okay, behind all these evil letters and where the wording might be nasty, so there are these persons, rational business people. And I think one of the benefits of mediation is that they are forced to meet face to face. Normally there might be some mediations virtually as well, but I think when the business people also meet face to face, so that's a clear advantage. And even though the case wouldn't be mediated during that mediation day, or not even a part of it, a part of the case would be settled. So I think most likely the case will be mediated or settled at some point of time. They might start an arbitration process, but at some point they realize that maybe still we should discuss. So I think there are many benefits of, in a way, forcing also people to meet face to face, and not only reading submissions from lawyers or letters from lawyers. And of course, I understand that then you live the dispute and lives the story. But when you're forced to meet, so I think there are good reasons for that as well.
And I think
so I'm very pro mediation, although my practice is mostly, of course, arbitrator work, but I see lots of benefits for mediation.
And I would second Heidi's point about, when the parties have met. I think my favorite example of where they then finally came together was a day before the award was going to be issued. So, we tried to mediate, then arbitrated, and then finally they decided to settle before. I have tried to get the outcome of the arbitrators, but I have not succeeded. So I'll keep on going until I find the answer, because of course for counsel it is super annoying, but for the client, of course, it's a great outcome.
Yeah. So I guess you both answered one of the questions here, that is, do you think that online mediation is as good as physical in person? Specifically, while ordering evidence, are there any concerns or disadvantages? Actually, these are two questions in one. Yes. And I think Heidi said about the in-person meeting, yes, face-to-face, how important it is, and Anna Maria also. And I think the second question, specifically while reordering evidence about concerns or disadvantages, this can be addressed by Bernard, because this has directly a relation to the use of documents during the negotiation or mediation process. Yes. And Anna Maria, there is also a request here to, if you please could spell the names of the two individuals.
I am writing.
Okay, great. And then also related to this case, there is comment about the different mediator background. What are the advantages, disadvantages of a legal background, or just social sciences, or maybe business administration? This is also an interesting question. Anna Maria, can you address it?
I think, I mean, and again, you know, happy to welcome Heidi's comments from a mediator perspective, but I do think that, and I actually think the same applies if you're sitting as arbitrator or as counsel, that if you have an understanding of human psychology and an understanding of human behavior, that certainly assists in most conflict resolution processes, because you understand that what the human is trying to communicate does not necessarily come across as what they're trying to say. Then, you know, whether you can actually use techniques, I think, you know, that applies both for witness work as well as conflict resolution, whether you're a mediator and arbitrator, to sort of form a setup where people who have been in a conflict for a long time all of a sudden start to speak openly. I think there's a lot of psychology that goes into mediator training as well. And I think this is where the elements of, you know, what you do in the plenary and what you do in the sort of separate session kicks in, is that you're trying to form trust between the participants into the mediation. So yes, and then I think, I mean, the other angle is in mediation, the questions are rarely legal questions, and as Heidi said, they will be resolved by the parties. So you also need to have a broad mindset, which means that in order to be agile on the business question, you have to have a very good command of the subject matter. And then either, you know, you bring the experts or you have your internal experts. But this is sort of one thing that I say to all the clients who I participate in mediations with is, you know, whatever Excel you have on the basis of which you're calculating, you know, the upside and the downside of what a potential settlement will be, you know, will have to play in every direction, because things will come up in the course of the mediation where you have to figure out very, very quickly whether this is actually advantageous to you or disadvantageous to you. And that's I think the hardest bit for counsel in mediations is that I can't prep my client enough, is that there comes an element where my understanding will be insufficient and we will be very deep within their area of expertise. And I think this is one of the things that sort of, you know, prevents counsel sometimes from pushing for mediation, because they're in a space where they themselves may feel that, you know, I'm not the right person to assist in this one. But actually that's where I think that the fun begins and generally the magic comes out. But yeah, Heidi, happy to pitch in from the mediator perspective.
Yeah. I think you made a very, very good comments. I always tend to say that even though you would be the best arbitrator in town or the best litigation or arbitration lawyer in town, so you are not necessarily suited for being a mediator, if you think about from mediator's perspective. As a mediator, as Anna Maria said, so you need to be able to listen to people, have the patience of seeing how they behave, and in a way you are not the lawyer that in the same way as you would be as an arbitrator or counsel in arbitration. And I think not all people are suited for mediators work. I recall when I participated in my mediator training many years ago, and there was a very experienced and reputable partner from an international law firm, and he attended the 1-week training as well. And at the end of the training, he said to all the other participants and the trainers that this was a very good training and I learned a lot, but I would never do this myself. So I'm not into this. So I do agree. So it's a totally different profession, and that comes back to your question of whether whether a lawyer is a good mediator or someone else. I think having a background for law is definitely a good thing, but you need to have also the people skills and different kind of other skills you need as a mediator. And then from the counsel perspective, So I understand what also Anna-Maria referred to, the idea of, as a counsel, you need to be prepared that in a mediation, actually your own client is the one who is speaking more, and you cannot control the process in the same way as you can control it in arbitration or litigation. And that's sometimes that you see as a mediator, you see that the counsel are not that comfortable in the situation because you cannot control what happens, and it's actually the mediator and the parties themselves that control the process. So it's something new for many counsel as well.
Okay, I guess we still have some questions about mediation, what we have to go on, otherwise we will not be able to address all the topics. And before going to Bernard, this is an important issue of the case, I want to hear from Henrik some aspects about the FCIArb rules. So Article 15 refers to the determination of jurisdiction, and it gives the board the power to either allow the arbitration to proceed or not, depending on the case and requirements that are met. And also Article 15.3 determines that the board decision is not binding and the arbitral tribunal shall decide on its own jurisdiction. And then there is Article 33 related to the jurisdiction of the arbitral tribunal. So can you tell us about these articles and the relation between the board and the arbitral tribunal in this particular aspect, meaning the decision about jurisdiction?
Certainly. So Article 15 of the FCIArb rules sets out the framework for the FCIArb board to make a jurisdictional decision in cases of jurisdictional pleas. And the main rule here is that the FCIArb board shall allow the arbitration to continue if it is prima facie satisfied that an arbitration agreement that they find the parties may exist. So this determination by the FCIArb board is done by a case-by-case basis, considering all relevant circumstances of the case. So, and those are of course then visible through the parties' pleadings in that part of the arbitration. And but here perhaps it's important to note that this is strictly speaking not a jurisdictional decision at all, but it's more of a administrative decision by the FCIArb board on whether to allow the arbitration to continue, in a sense that the FCIArb board or the FCI proceeds with appointing the arbitral tribunal and then eventually transmitting the case file to the arbitrators. Whereas the Article 33, which you also mentioned, is basically the illustration of the competence principle, according to which the arbitral tribunal shall determine its own jurisdiction. So what the FCIArb board does not affect the tribunal's decision making in any way. Do you, Heidi, want to mention any examples of where the FCIArb board has made these kind of prima facie decisions?
If I think about our board meeting today, so for instance, in a situation where, as we had today, we had one case where the respondent didn't file an answer to the request for arbitration. So they have been passive, and we had to decide whether we are prima facie satisfied that an arbitration clause exists, and we have jurisdiction in order to move forward to, in this case, we decided on the number of arbitrators. But that being one example of the situations where we need to, according to the rules, make the decision. Of course, another example would then be if there is really a jurisdictional plea from the other party.
Exactly. And these are actually quite typical, statistically speaking. I would say that last year we had between 10 and 15 jurisdictional pleas that the FCIArb board then had to rule on based on this prima facie decision making.
Okay, that's a great number, yes. I mean, if you consider the numbers you gave us before, so I mean, the board must be very busy considering these issues.
Yeah, considering the figure that you just said, and take into consideration that we have a meeting once in a month with the whole board. So basically, in every meeting, we will have at least one jurisdictional decision to make, this kind of administrative decision, as Henrik explained.
Okay, thank you for your answers. And I guess now we are turning to another important aspect of the case related to the request for exclusion of a document that is claimed to be under privilege. And on the other hand, the maintenance of a document that also could be under privilege or confidentiality rules. So Bernard, I think this is not the first time that this issue appears in a Vis Moot case, the use of documents that could be in a tricky situation. So what can you tell us about this?
Thank you, Cristina. My idea here today, as we do not have that much time, is to make a brief brainstorm regarding the exclusion of exhibits R3 and C7. And I'll use some visual aids to help us go through this in a workable way, considering the number of issues that may arise during this. So please let me know if my slides are showing up before we proceed.
Yes,
perfect.
I can see it, yes. So
just to begin, two brief caveats. First, this is not the opinions of the Finland Arbitration Institute. These are not the opinions of my colleagues here today. This is merely an exercise of brainstorming on the possible arguments to be made by claimant and respondent, considering that we are just now beginning the oral stage of the Vis Moot. The second caveat is that, considering the time restriction, we do not have the time to go through each and every single individual possible argument. And even particularly consider there are many roads to prevailing the oral arguments. There are many roads to prevailing vindo bona. So please be aware of that and do not take this brainstorming as a limitation for your creativity on the oral arguments. So let us begin. The issue 2 posed by PO1 of the case is, should the arbitral tribunal order the exclusions of exhibits C7 and R3? Just a quick reminder, exhibit C7 is a without prejudice offer from respondent to claimant, asking a 15% price reduction to continue further discussions. And exhibit R3 is an email from claimant's head of legal department to its CEO and its head of contracting regarding a possible misrepresentation in an email to respondent. So let's begin by addressing exhibit C7 that respondent wants to exclude. Some of the arguments that may be made relate to, first, the FIA mediation rules themselves. Articles 15.1 and 15.2 of the FIA mediation rules provide for confidentiality in mediation. And as you may see, while Article 15.1 establishes that any statement and information made or obtained during mediation is confidential, Article 15.2 states that any information obtained in the context of a FIA mediation is also under confidentiality. So one argument that the respondent may make is that the differing wording of Articles 15.1 and 15.2 lead to the conclusion that 15.2 is broader than Article 15.1 and could be argued to cover a document made during negotiations, considering that the parties agreed that they would go to mediation afterwards. Of course, this is not a clear-cut argument for respondent, and claimant, on the other hand, may argue that the parties did not effectively go to mediation. So it can be considered that these rules would not apply to the case at hand. But regarding also the FIA mediation rules, there's a second possible argument to be made regarding the previous negotiations between the parties. as we see from Exhibit R1 and Exhibit R2, it is clear that respondent's negotiator was under the impression that the parties reach an agreement that negotiations would also be covered by the Article 15 until 5 mediation rules. On the other hand, we see on Exhibit R2 that the email used to reach that conclusion is not entirely clear on the matter. In fact, when in its email, claimant states that regarding the confidentiality of the foreseen ADR mechanisms, and neither of the parties addressed specifically in their arbitration agreement prior negotiation to arbitration. So, like on the other case, we have arguments to be made by both parties. Moving forward, we can also, respondents may also argue under without prejudice privilege, that is, a privilege that applies to information and documents producing in the course of settlement negotiations. What is the applicable law on our case here regarding without prejudice privilege? Exhibit R4 makes clear that, at least in Danubia, the seat of arbitration, there is insufficient protection in this regard, and it, as a matter of fact, are constantly used in subsequent arbitration proceedings by the opposing party. And PO2 on question 30 also says that there is no case law or jurisprudence in Equatoriana, Danubian, or Mediterranean as to what the term without prejudice means and how documents with that label may be used. So at least from this point of view, the applicable law does not seem to help us that much. However, there is also a possible argument to be made on policy. If we allow the parties to use information and documents produced during settlement, two things occur. First, the parties may be less candid in their offers. They may be less willing to compromise their positions in order to reach a settlement. And this would go against public policy. On the other hand, it is also a question whether or not statements made during negotiations could be considered as evidence, considering that at that moment, both parties are trying to compromise to reach a solution. And I bring here only one example of those policy reasons that may be argued by the parties. We'll come back to the without prejudice privilege at the end of the presentation, but now let's move on to our Exhibit R3. The first, just remember, claimant wants to exclude Exhibit R3. The first argument that could be made regarding this issue, although I believe that individually it's a problematic argument considering the facts of the case, is that the exhibit should be excluded as it was illegally obtained. So, what is the source of the document according to the case? We have no clear-cut evidence on this regard, but at least from the perception of claimant, the document was obtained, as Cristina previously mentioned, when the police raided and confiscated all his documents, and most likely has shared this later with claimant. With respondent. On the other hand, it is also possible, and this is stated in item 8, that the document was simply leaked by an employee of claimant in some point in time. So, we can argue that this document was, if it was obtained during a police raid or if it was leaked in breach of the confidentiality agreement, was illegally obtained and as such should be disregarded by this arbitral tribunal. As a matter of fact, the IBA rules themselves on Article 9, paragraph 3, state that the arbitral tribunal may, at the request of a party or on motion, exclude evidence obtained illegally. However, on the other hand, there are two issues here. First, as I mentioned, the facts of the case do not make entirely clear how the document was in fact obtained. So you have to argue in a vacuum that it is illegally obtained. On the other hand, the IBA included may instead of shall in Article 9, specifically to address that this is not an issue that is easy to decide. It is not easy for an arbitrator to conclude that a document was illegally obtained. So it left for the arbitral tribunal to decide it using the word may instead of shall using other paragraphs. Now, most likely the main argument that would be made by the parties in this case regards attorney-client privilege. As we mentioned before, Exhibit R3 is an email from claimant's head of legal department to its CEO and its head of contracting. But what is the law on the case regarding attorney-client privilege? Exhibit R4 mentions that Danubia and Mediterranean have a situation where there are no clear-cut legal rules, only a provision that communication between counsel and client is to be kept confidential under the ethical rules for lawyers. On the other hand, Equatoriana follows the American approach of a more comprehensive dealing with attorney-client privilege. So, if you're arguing as claimant, most likely you want to approach it applying more comprehensive rules, while as respondent would try to argue for less comprehensive rules and argue that our Exhibit R3 are not covered by them. As a matter of fact, it's not entirely clear-cut under private international law. Under private international law, how should arbitrators decide matters of attorney-client privilege? What is the law applicable? And the IBA Task Force on Privilege on its page 5 of its report found at least 4 different ways that arbitrators have previously applied to decide it: the connecting factor, the closest connection test, the most favored nation, and the least favored nation approach. So we have ways to argue both from claimant and from respondent side. Claimant, for instance, may argue the most favorable nation, leading to the law of Equatoriana and most likely to the exclusion of Exhibit R3, while respondent may argue the closest connection, most likely leading to the law of Mediterranean. Consider that claimant is a Mediterranean company consulting its Mediterranean bar in-house counsel, so it could not have legitimate expectations of privilege. We could also argue it if we decide not to follow specifically the laws applicable to the case under policy. If we allow parties to use communications exchange between clients and its counsel, we may be hindering justice as we incentivize the client not to be candid with its counsel, preventing it from properly analyzing legal cases. So this is another possible argument to be made. We mentioned some arguments regarding Exhibit C7, some arguments regarding Exhibit R3, but there are also arguments that may address both situations, or those are arguments made under the IBA rules on the taking of evidence. But the first question here is, why would the IBA rules on the taking of evidence apply? The case law the case of the Vis Moot case simply does not mention them. However, both the Procedural model law and the FIA mediation rules give the arbitral tribunal the power to determine the admissibility, relevance, materiality, and weight of the evidence. So it may be argued that lacking an international standard chosen by the parties, the arbitrator could go to the IBA rules as an international standard to apply. But why would the IBA rules on the take of evidence be relevant? This leads us to its Article 9, particularly its subparagraph 2, that states that the arbitral tribunal shall, at the request of a party on its own motion, exclude from evidence documents, testimony, for the following reasons, and B states legal impediment or privilege under the legal or ethical rules determined by the arbitral tribunal to be applicable. And here I have a point to make. As stated on item B, this analysis is under the legal or ethical rules determined to be applicable. So the point that we made previously regarding the possible applicable laws also holds value here. So item B also leads us to Article 9.4. And Article 94 on item A mentions attorney-client privilege. On item B, without prejudice or settlement privilege. And on item C, D, and E, and I've chosen here C and E because I found that more relevant, other considerations to be considered regarding these privileges. So it may be argued on this from the standpoint of claimant that there was no expectation from respondent that this document should be kept confidential under Article 94C, or that, on the other hand, claimants could argue the need to maintain fairness in considering the most favorable nation rule, it should exclude the exhibits R3. On the other hand, regarding C7, we could also argue that there was no expectation regarding the without settlement privilege, considering that neither law of the case specify this kind of privilege. So we have possible arguments to be made by both sides. And on this note, I would like to go back to my first caveat and stress to you, there are several possible ways to argue this case orally. At the end of the day, all roads lead to Hindubono. So without further ado, this ends my presentation. I'll ask you, if you cannot answer your questions today, please take note of my email. I'm willing to answer any questions you have by email also. So once again, thank you very much, Cristina, for inviting me here today.
Thank you so much, Bernard. You have this characteristic to always present a very structured understanding about the case. I remember the one you brought last year. I printed it and used it in my preparations for the hearings. It's because it's a lot of information, and I strongly recommend the students that are watching the video that watch this part again and take notes, or the arbitrators that will be there, because this is how you can ask Moody's tricky questions, not tricky, but important questions related to applicable law, jurisdiction, because at the end all goes to these elements. Yes, you have different ways to presenting the case. You have different ways to consider, different ways to analyze and to form your opinion. So this again, it comes the background of the arbitrator and the legal system in which this professional is used to act. So I ask if one of the other speakers have some insights to give about this issue.
I think we refrain from commenting, or do we?
That's correct.
But we are happy to use the slides which you have when we are coming to Vienna.
Yes. Well, I'm giving an advice to the Moody's and the audience. If you have any questions about this issue, you please send them to Bernard directly to his email, because I think this will be more efficient. I would like to go back to some of the questions that participants brought us in the Q&A. And there's one that I want to ask Henrik about. It's the, where is it? If there is information, so if it's possible to find finalized mediation cases online, settlements, etc., like in arbitration. So how are the FI rules? I guess confidentiality applies, but are there cases that the decision is publicized?
Unfortunately, no FAI arbitration or mediation decisions or awards are published, so I can't, unfortunately, direct you to any relevant sources here. But speaking in general, do you, Heidi, know if there's some other like mediation decisions that have been rendered in Finland that you would be aware of?
If we think about private mediation, so my answer would be no, because you normally wouldn't have an award to be published. You would have a settlement agreement. Of course, there might be some discussions in media about some firms doing a settlement in a dispute, but as to the settlement agreements, most likely you wouldn't find them. As to the court mediations, I don't actually know, Anna-Maria. Have you had any cases in court mediation? And what's about the court mediation situation? Most likely they wouldn't publish the settlement agreements either.
I actually,
have you had any?
The only ones I've had, they've proceeded all the way to a judgment.
So
that wasn't the issue. And this goes back to the point that often the ones where I end up in court are with public entities, and then if they've decided to take it all the way, it's hard to change. And I think that's more a mentality thing than it is a legal point. So it's more a question of, the agreements may have been done by a public servant, and then now the issues are in dispute before another one. So, nobody wants to take responsibility for this. So that to me is the sort of the driver behind that. I think, in practice, what we see in our practice is that there's a tendency to actually initiate the arbitration and then suggest to bring the mediation at the same time. And what I've had a number of times is I've been appointed the arbitrator, whether under the FCIArb rules or other rules, and then the parties have either conducted a mediation or settlement negotiations. They come back with a settlement agreement, and then they ask me to confirm the settlement agreement as the arbitrator. So I think that's the easiest way to get it to circulate. And I think before we have practice under the Singapore Convention as we do under the New York Convention, this is going to be the preferred way, because then you don't have to ask any questions. This is going to work. It leaves the arbitrators a bit in the dark, but
Anna-Maria, going back, I think I know you already said that, but it wasn't so clear for me. So the question is related to arbitration with public entities. Yes, so you said, but it was too fast. I could not understand. So how is arbitration with public entities in Finland? So are they submit to commercial arbitration also, or it's only the investor state system, or both?
Well, to me, it's a pink elephant. So, it doesn't exist, but Heidi and Henrik, feel free to step in, because what I see in the commercial practice is whenever we go to court, it's always against the public entities, because they have the possibility of strong-arming the commercial party to accept a court clause, especially if you're dealing with municipalities or and then, of course, you land in administrative proceedings when the dispute is with an authority of the government. Then when we talk about the state of Finland, then this is different, obviously. And Finland is a signatory to the Exit Convention. The first exit case is ongoing against the Republic of Finland. Finland has thus far not been, one of the states in the European Union that leads the statistics on investor state cases, and I hope that statistic is not about to change drastically. But I do think that we are seeing a more active market in that context. There was a sort of fairly minor case against the Republic of Finland brought a few years ago that is over, according to my information. And I think in the past, some 15 years ago, there's been a case by a Finnish investor, but I think this is the first time Finland itself is subject to treaty cases, and we will watch the space closely to see where. But I think from that perspective, what I could say from a general as a general statement, is that Finland abides by its international obligations and is signatory to the main conventions, the ICSID Convention, the Mauritius Convention on Transparency. And I think, the information that is out there is also publicly available to the extent that the cases have been brought. So that research can be done with anyone with access to the internet.
Okay, so we reached.
And actually, Cristina,
ending. Yeah.
one thing that I can follow up on that is one of the reasons I think that drives the point about commercial arbitration not being the preferred venue for public entities is our Freedom of Information Act, which is the openness of government doings. So any government entity will have to be as open about its doing as possible. And from that perspective also, then the disputes are subject to the public courts. And that's just, the way our governmental system has been built.
Oh, okay. So we just a brief information about how it works in Brazil, because Brazil is not Washington Convention signatory, and we public entities use commercial arbitration, and they are under transparency rules. So meaning that all the arbitrations related to government or public entities, they have to be open, and there are all the information related to the information are publicized on the websites from the entities. So it's so Cesar, he's not. I think he's watching. He wrote a very interesting article about it. But anyway,
maybe it's an idea for the FAI, and I think, our courts are not necessarily the fastest at the moment, so maybe it's an idea for Heidi and Henrik to take forward.
Yeah, I think we have talked about this issue at some point already, so it's something to continue to elaborate on.
Oh yes, we can talk in Vienna. I have a lot of experience with that. So
okay, good to hear.
Okay, so we are heading to our ending. I really thank you a lot. I think it was very, very interesting, and hope to see you in Vienna, as I said. And I invite the entire audience to keep watching the webinar, to watch our second part on the 5th of February at 11 o'clock Brazilian time with Ingeborg Schwenzer, Edgardo Munoz, and Cesar Pereira. So I think that's it. I hope you enjoyed it, and thank you very much again.